All right, welcome back. Everyone's doing well? Yeah? Okay, has everyone picked up their exam? Good. If you haven't, do so quickly. A significant number of you actually emailed me to schedule times to meet, which I'm very happy about. That's why I'm doing this exercise. For those of you who haven't, you're welcome to do so. I ask you just first to review the A+ answer and review the exam so you have a sense of where you are. And then I will talk to you for as long as you need. Okay? Any question at the exam? Yes, sir.
Real quick, was Simba gifted the land or was it sold to him?
Was he gifted or sold? It was, I didn't mention money, so I guess it could be conceived as a gift, but it didn't really affect the outcome of the question at all. The issue that did matter, though, was whether it was an inter vivos gift or a testamentary gift. And if you recall, Mustafa said, or Mufasa, as it were, you can have the land after I die. Right? That's a testamentary gift, which must satisfy the statute of wills and have the two signatures. There was no delivery in the immediacy, so it wasn't a valid gift or payment. Either way, it wasn't valid. But I don't think I specified. Other questions? Okay. So we're moving on from servitudes. Servitudes were probably the trickiest doctrinal concept we have for the entire semester. What we discuss easements, and we discuss covetitudes, and we discuss equitable servitudes, and all these other means by which private parties can control how their land is used. Okay? And if you'll notice, virtually every single property case you studied from your first day of property 1 till today involved private parties. You'll notice that unlike virtually everything you study in common law, nothing involves the government. No one's suing the government's not suing anybody, right? These are always two private parties engaged in a dispute over some sort of private transaction. Today's class changes that. And we move further into the 21st century, or really the 20th century, and discuss how government regulations affect property. What you'll notice from every case here on out is that the case is person versus government, right? Or government versus person. We are no longer dealing just with private means of property control, whether they're future interests or easement or covenants or whatever. We are dealing with government regulations. Okay? And before we go too far into how these government regulations work, I want to push you a bit on why we move from an arrangement where private parties control their land to an arrangement where the government controls land. Okay? Where did I finish up last time? Out there? Okay. Yeah, okay. I'll start with you, Michelle. So, Michelle, going back to our first couple weeks of class, right? Oh, I forgot to mention. I love how they put this here. So I always want to start walking this way to see the reminders. So tomorrow at 11, there's a discussion on Justice Thomas. And I realize I'm not your property professor, but we will, not your common professor, but we will study his opinion in Kelo. His assent in Kelo is very significant in the main case. If you don't know much about Justice Thomas, you should come. Also, Professor Paulson, who's extremely entertaining, who I assume you have Paulson? No? Okay, well, he's extremely entertaining. So if you're around tomorrow at 11, I'd strongly encourage you to stop by. You'll learn a lot. Ralph is a good friend and a really smart guy. A lot. Anyway, I put it right here. I always see it as I'm walking forward. So, Michelle, going back to our first discussion of easements and servitude, right? If someone was polluting downstream from you, right, and this was the 1800s, what would you do to stop that pollution? He was dumping, oil into the water or whatever. What were your options? We have some options. We've discussed different things, the common law. What were your options? Yeah, you can sue for a nuisance. Okay, good. What else did you do? What topic did we just finish? Right, and how could you use a servitude to stop the pollution? How could you get someone to stop polluting using a servitude thing? We just did this entire topic. Josh, what do you think? How can you get someone to stop polluting using a servitude? It's not your book. Look at back here.
Just restriction.
Yeah, what would you do?
The limit the amount of pollution.
How would you do that? What means would you use? What did we just spend 3 weeks studying? What? How can we do it? No. How can 2 parties without the court control the use of property? Yes! Create an easement. Create a negative easement saying this property will not pollute. And I will pay you not to pollute. Right? What else? Right? What else, Peter? What other means could you use instead of an easement? What else could you do? A covenant, right? This was the example you used. Do not build a factory on Blackacre. If you build a factory on Blackacre, we can sue. Okay? This one should have been hard. Apply what we've learned. This one wasn't too difficult, right? So there were methods at common law that you could have used to stop bad land use. You could have sued for an injunction on nuisance. You could have sued for damages on nuisance. You could have sought to create a covenant or an easement that restricted the usage, and you in fact have to pay for the right not to have the pollution near you, right? But all these assume 2 parties. There's the party making the pollution, and there's a party getting polluted on, right? Stephen, what happens if there are 5 properties downstream from this factory? 5, let's make it easier. 5 properties downstream from this factory, and they're all getting punished by this pollution, by this oil leaking through, right? How would those 5 property owners now attempt to stop this pollution?
Sue based on privity.
Okay, who would they sue?
They would sue the original grantee.
You're making this way too complicated. They sue the person polluting, right?
Oh, yeah.
Okay, but what's the problem when you have 5 people trying to sue the same party? What's the problems there?
You don't know all of them.
Privity has nothing to do with this. If someone's creating a nuisance, you can sue. You don't need privity to sue for a nuisance. They're not suing on the covenant. They're merely suing for a nuisance. Did you understand? Okay, so what's the problem with 5 people trying to sue the same party that's polluting? Nothing with covenants, just talking about a nuisance here. What are some of the practical difficulties with 5 parties suing to stop a nuisance?
They all have to approve the nuisance.
They'll have to what?
Approve
What
the
do you
nuisance
mean?
to them individually.
Okay, and generally speaking, what's the problem with 5 people trying to do something together? Think of 5 of your friends trying to go see a movie.
It's complicated.
Why? Why does it complicate things?
Because just multiple parties trying all to sue at once.
Right? What do you think, Ben? What do you think some of the difficulties are when multiple people, I'm doing this for a reason, when multiple people are trying to sue the same defendant? What do you think some of the difficulties there are? What do you mean?
Well, I guess when it relates to nuisance, you don't know who the defendant is damaging more, and if you were enjoying the action, how would you say he's causing more damage to the others? It's downstream sort of thing.
Okay, so let me ask you this question, Ben. Follow up. Let's say that the house closest to the factory has the most pollution, the house next down the street has a little bit less, and each subsequent house has less pollution. Do you think all 5 properties are going to be equally eager to sue?
I guess it depends. If it was for damages, and the last house could try to that sort of thing, but if it's an injunction, I guess the last house farthest away potentially better.
What does it take to file a lawsuit? No. Much more practice. What's it take to file a
An
lawsuit?
angry person.
What does angry person have to do?
For the case.
No. Who files it? Why are all you in this classroom?
Attorney, we need a lawyer.
And what do attorneys need to file lawsuits?
Money.
Money! Oh my gosh. Okay, you guys, right? You are in this room for a reason. That God willing, one day you all pass the bar and get a job and someone says, I'm angry, I want to sue. Okay, give me a retainer, right? Pay me. What I'm getting at is this. Enforcing environmental lawsuits, for example, through piecemeal, one-by-one litigation is very, very difficult. Okay? Why is it so difficult? First, how can you get everyone on a block to agree to sue? Anyone ever see Aaron Brockovich? right? It's not easy. Maybe you need Julia Roberts and punts or something, right? It's not easy to get everyone to agree to sue. But even more so, even if you get everyone agrees to sue, how do you pay for it, right? How are all the people in the community going to be sufficiently interested, invested into putting money into these sorts of lawsuits? And I think Ben raised a fair point. Even assuming that everyone on the block agrees to sue, they're not all injured equally. Depending how close they are to the nuisance, there's different degrees. So do you then, I guess, adjust the attorney's fees based on their likely recovery? That's not very realistic. You guys are not going to base the amount of money based on how much injury would be. You say, here's my hourly rate, unless you do a contingency, which is a different story. Okay? It becomes very difficult to police land usage on any large scale. Now, one approach that seems to be pretty effective is subdivisions. We've discussed subdivisions where you put a restrictive covenant on every piece of land in a subdivision, right? That way every house looks the same, every house is the same side of a yard, everything looks the same. What happens to houses that aren't in subdivisions? What about houses that are in just regular blocks and that you can't restrict them through covenants and deeds? And then it's not practical to sue anytime someone enforces it. Okay? So everyone sees the difficulty in somewhat large urban environments of using easements and covenants to control land use. Everyone with me so far, right? Ask me a question. Okay? So in the early 20th century, recognizing the deficiencies of using easements and covenants and nuisance law to regulate land use, the idea emerged of, instead of private parties arranging the use of property and arranging land use, the government would create land use. Now, this was a radical innovation. I don't think the book even does a good enough job to explain how radical this was. Historically, your land was your castle, right? We say this in the first day of property. Your land is your castle. You can do with it whatever you wish. You can exclude whomever you wish. Remember the right to exclude in the bundle of sticks. Okay? But now, this idea of zoning was that the city or the town or whatever the jurisdiction could tell you not only what to build on your land, not only how to build on your land, but that you couldn't build on your land. Okay? This was a serious change in the way a law went about of regulating property usage. And this began, unsurprisingly, in the cities, in urban environments. And the Euclid decision somewhat hints at this as well. There was this notion that in very dense urban environments, okay, it became difficult for people to coexist because you had industry, you had residential, you had commercial, you had different types of usages compressed in a very small area. And people didn't like this. Okay? So zoning emerged from a host of factors, but primarily to control the use of property in urban areas to make it conform to some broader vision of what a city should look like. So we get that much, right? You can do this to an extent through covenants and easements, but not very much. For the simple reason that you can only bind people, you can only bind property where there's privity, which is what I think you were getting at, right? But we discussed privity is difficult. This, by the way, is why in the 20th century courts relaxed privity requirements. They wanted to make it easier to control land, even before zoning laws came around. That's why under the common law of privity, it was almost impossible to bind a piece of property unless they agreed to it and there was a transaction of land accompanying it. The 20th century, those standards were relaxed. Okay? So we get the history of why zoning became relevant. Okay? So, Evan, didn't forget about you. You always one row back. Evan, what then is the biggest obstacle to zoning? What was the greatest obstacle in the early 20th century that zoning advocates faced?
Sure.
What's the entire theme of Euclid? What's Euclid about? It's the only case we have. What's the biggest obstacle we have facing zoning in the early 20th century? And why is that a problem? What was the case about? Did you guys listen to the reading this week? Something's off today. Okay, no, stay with it. What was the case? What was Euclid about? Did you read it?
Yes.
What was it about?
Whether it violated
The Constitution. Right. Historically, there was no such thing as a government regulating the use of land. Okay? That did not happen. There was no regulation of land by the state. If you want to regulate land, you reach a covenant or an easement where you sued for an injunction, right? But it's always private parties controlling the use of land. When zoning laws first came out and were first introduced, the greatest potential threat was indeed the Constitution. Okay? And there are two provisions of the Constitution in particular that we have to talk about. Okay? Norma, what's one of them? Okay, good. So Norma said, if the government wants to take your property, they have to pay for it. Where's that clause appeal, Norma? Okay, so have you done incorporation yet in common law? Okay, so if I may pivot for a bit. Did you do incorporation? Okay, I'll do it now. So the first 8 amendments to the Constitution, right? First Amendment begins, Congress shall make no law, right? Congress shall make no law abridging the freedom of speech. When the Constitution was first drafted and the Bill of Rights were ratified a couple years later, the first 8 amendments only applied to the federal government. You know a case called Barron v. Baltimore? Okay. In Barron v. Baltimore, Chief Justice Marshall held that the takings clause of the 5th Amendment, I have it up here. Okay, this is one that Norma's referring. Okay, the takings clause of the 5th Amendment, which says, nor shall private property be taken for public use without just compensation. Okay, nor shall private property be taken for public use without just compensation. That's the 5th Amendment. In the case of Barron v. Baltimore, the Supreme Court held that the 5th Amendment did not apply to the states. That if the state of Maryland wants to take property, they were not required to pay compensation. Okay. But what happened? Okay. That was like an 1808 case, give or take. The 14th Amendment, though, changed that dynamic. Now I'm grossly simplifying here. The 14th Amendment says no state shall deprive any person of life, liberty, or property without due process of law. Right? The 5th Amendment only applies to Congress. The 14th Amendment applies to the states. The 14th Amendment puts limitations on the states. Now, is there anything in the 14th Amendment that says states cannot take property without compensation? The answer is not directly. So here's what the Supreme Court did over many years. They look at the word liberty, right? No state shall deprive any person of life, liberty, or property without due process of law. What does that word liberty mean? Okay. What is the substance of that word liberty? What the Supreme Court has done, which is probably correct, that's the way they did it, was they said the first 8 amendments of the Constitution, that's what liberty is, plus some other stuff. If there's a right protecting the first 8 amendments of the Constitution, okay, that is what the meaning of liberty is. So the decision goes all the way back to the 1890s. The Supreme Court said that one of the liberty interests that we have under the 14th Amendment is that the state cannot take our property without just compensation. Let's say it again. Going all the way back to the 14th Amendment, they said, one of the liberty interests that we have that the state cannot violate is the protection of private property. If the state, not just the federal government, but if the state wants to take our private property, they must pay just compensation. This is what is known as incorporation, that the provisions of the Bill of Rights were incorporated or extended through the Due Process Clause to now apply to the states. So whereas before the 14th Amendment, the Bill of Rights only applied to the federal government, after the 14th Amendment in subsequent years, the Bill of Rights controlled the states as well. So now if the state wants to take your property, they are constitutionally obligated to pay just compensation for it. That makes sense. One of the biggest discussions of constitutional law in the 20th century is whether the Bill of Rights should apply to the states. The right to a jury, the right to free speech, the right to bear arms. One case at a time, the Supreme Court said that this applies to the states, and that right applies to the states. But originally, the Bill of Rights did not apply to the states. So now, if the state of Texas wants to take your property, they must pay just compensation because it will deprive you of a liberty interest for that due process of law that is the takings clause. Everyone get that? Questions? Should have learned this in common law, but I will gladly backfill. Remember I said people always always like, he's teaching common law. You need to know it for this case. Happens every year. What was that?
Said no complaints here.
Fair enough. Okay. So Norma was mostly right when I asked her what provision of the Constitution. She said the 14th Amendment's takings clause, which was close. Okay. But there's another provision of the Constitution by itself that is relevant. Now, did you guys study, I'm sure you say substantive due process and Lochner. Do you say this? Oh, I say Lochner, everyone knows what that means, right? So Lochner is one of the most unfortunately bastardized cases in Supreme Court history. Okay? But we look at the 14th Amendment and it says, nor shall any state deprive any person of life, liberty, or property. Huh. So not only is the word liberty there, the word property is there. And it says you cannot be deprived of your property without due process of law. So, Dominique, you're up next. A second charge that was brought in Euclid, which was really the main one, is that zoning laws deprive a property owner of their property without due process of law. Dominique, how would zoning deprive an owner of land of his property without due process of law?
Because you're tired of the one who's standing that property.
Good. And is there any sort of check on this process? Ah, okay, very good, good. So the argument goes like this. The zoning laws, the argument went, take away our property. It says, I own this piece of land, but I can't build on it what I wish. That's depriving me of property. And what sort of process is given? I basically have to go to court and sue on it. Okay? Is this sufficient process? Well, the argument went, no, right? In other words, these zoning codes were imposed across the entire city, right? Without any specific findings on a particular land. Go thinking of the Euclid case, right? He had a lot that he wanted to build on. They didn't go and check with him first. They just imposed this entire code on the city. And the argument was that this by itself violates property rights without giving any sort of process of law. That you're not giving any sort of hearing before these restrictions are imposed. You need to go to court after and sue on it. And you have a very, very high burden of proof to get past those restrictions. So there really are two constitutional arguments against the legality of zoning. First is that it deprives a person of property without compensation. It amounts to a taking of private property without just compensation. Second, and this fits into the broader so-called Lochner era, it amounts to a violation of a property right without due process of law. That they're not given the appropriate process prior to taking away your property, or at least depriving of value. Okay.
Could you repeat the last sentence? It amounts to a violation of substance due process.
Yes, because it deprives you of property without affording due process of law. That you're not given the appropriate process prior to the deprivation of property. Okay. So those are two major constitutional arguments against the legality of zoning law. Any questions on those? Stop me if you do. I think you guys didn't do takings in common law? Okay, some professors actually do cover that, so we'll do it the first time here. So those are the greatest arguments against the constitutionality of zoning laws. Okay? Josh, what is the state's argument in favor of the legality of zoning laws? What do states rely on? What authority do states rely on to enact these laws? I'm sorry? Well, if it's a nuisance, can't people sue on it? Josh, let me ask you a question. Where does the state get the power to pass laws? Let's make it easy. Criminalizing, I don't know, drunk driving. Where do states get that power? No, state law. Where do the people in Austin, our fine representatives, where do they get the power to enact a law that says drunk driving is illegal? Oh, wow. Anybody know? Good. The police power. And you don't learn about the police power. What's the police power?
It's the power the Constitution delegates to the states to regulate themselves. That's probably not a great definition.
Almost exactly right. Okay, almost exactly right. So, again, this requires some common law. So originally, right, before we had states, we had colonies, right? And before we had colonies, the king was in charge. And the king had entire sovereignty over passing laws in the colonies. Indeed, one of the Declaration of Independence grievances was that we couldn't pass our own laws. What happened when we declared independence and the colonies became states? What happened to that authority to pass laws? It devolved to the states. The states basically embraced the power of the king to make laws. Okay? And then what happens when the states and the people of the states ratify the Constitution? Some of that lawmaking power was given away. The states gave up some of their authority and delegated it to the central government. Okay? Pay attention which way it goes. It's not the federal government delegating authority to the states. It was the states giving up some of their own authority to the central government. So, for example, the central government can declare war, regulate interstate commerce, and do various things that a central government ought to. But the states retained this wide mass of authority to enact laws, known as the police power. And indeed, it's reflecting the 10th Amendment, right, which says the powers not delegated to the United States, nor prohibited by it to the states, are reserved to the states respectively or to the people, right? The powers not delegated to the United States are reserved to the states respectively or to the people. What does that mean? Whatever powers the states did not give up to the federal government through the Constitution, the states were reserved. And this is what is called the police power. The police power of the states. This is what gives Texas the power to enact laws prohibiting drunk driving, for example. So what is the scope of the police power? Broadly defined, it's a power to regulate the health, safety, welfare, and morals of the people. The power to regulate the health, safety, welfare, and morals of the people. Now, does the federal government have a police power? No. The federal government cannot do anything they want to promote the health and safety of the people. The federal government is a government of enumerated powers. Should sound familiar. They can only do that which the Constitution authorizes them to do. But what about the states? Okay. What about the states? The states can basically do just about anything they want, so long as it does not violate the federal Constitution. The states have virtually unlimited authority to enact laws to protect the health and safety of the people, so long as it does not violate the federal Constitution. So we have this tension, right? The state has this police power to regulate the health and safety of the people. But if that police power crosses a line and amounts to a taking of property, you have to pay just compensation. If that police power crosses a line, it deprives someone of property without due process of law. So the exercise of this class, really the next couple classes, is trying to draw the line of the appropriate scope of the police power. Where does the police power end, and where does the takings clause begin? Where does the police power end, and where does the due process clause begin? Right? If a government is acting under its police power, and I'll give you an easy example. Let's say they pass a law saying that you're required to have, I don't know, a fire escape on an apartment building. Easy example, right? There's a pretty good argument that that is being done to protect the health and safety of the people living in that building, right? No one would disagree with me. But you're still requiring someone to install and drill at their own expense a fire escape into their building. Is that a deprivation of their property rights? Is that a taking of their property without due process of law? Are you required to give compensation? It depends who you ask. But this is a question we're going to have to deal with this semester, right? How heavy of a restriction can the government put on a piece of property until it crosses over to being no longer police power, but an act of a taking without compensation, or an act of a deprivation of property without due process of law? Okay, that is the nature of our question. So in every case we decide, the government loves saying, oh my God, this is police power. This is the easiest example of the police power, right? The zoning, it's all police power. But the property owner's like, oh, this is not police power. This is a taking, or this is a violation of due process. So in every case, the property owners will be saying that this is a taking or due process violation, and the government will be saying that this is just police power. Why? Because if it's police power, they don't have to pay compensation. If it's a taking, they do have to pay compensation. And the government doesn't like paying money where they don't have to. So that's the entire struggle of these cases. Okay, any question on the background of the interaction between the takings clause, the due process clause, and the police power? It's a somewhat subtle concept, but you will need to understand this to get this topic. Any questions? Anything? No? Okay. All right, let's move on to Euclid then, okay? All right, Mike, what were the facts in Village of Euclid versus Ambler?
So this was happening fairly far the 20th century.
Mhm.
City of Cleveland's moving out, expanding. They're enacting some zoning ordinances which designate this man's parcel of land in 3 different tiers for building purposes.
Okay, very good. So a little bit of the background of why this case is where it is. I like that in the introduction they quote the district court opinion, and they usually don't bother quoting the district court opinions, but I think this was done very deliberately. The early 20th century, I'm sure you cited this part in common law, was a period of great constitutional change, because many of the doctrines of the Constitution, the takings clause, the due process clause, were flatly inconsistent with the progressive state, right? Many aspects of the progressive state, in this case land use regulations, were not consistent with how traditional property rights were understood. And the court recognizes as much in their decision. So in the 1920s and also the 1930s in particular, the Supreme Court began altering some of its long-standing property doctrines to effectively usher in and pave the way for many of the progressive ideals that were exemplified by the New Deal. But not all courts were on the same page. And the district court in this case found that the zoning ordinance was unconstitutional. Ryan, what did the district court say, the trial court say, of why this zoning ordinance was unconstitutional?
It basically says that placing the property in all this area in a straitjacket.
Yeah.
That's usually binding so that they can't like have freedom.
Yeah. Ryan, who does the district court think that this law is probably going to be hurting the most? He kind of hints at it.
It seems to say like families, single families.
No. On what grounds, Ryan, is this land being segregated?
It's segregated family housing, apartments.
And generally speaking, what decides if a person lives in a family house, a one-family house, or an apartment? What decides that? Bingo, money. The district court explains it like this. Zoning allows segregation according to income. Zoning allows segregation according to income. The district court, who seems like a pretty smart guy, is like, listen, people don't live in crowded apartments if they can afford houses, right? That seems like a pretty obvious idea. If you can afford a house, you're probably not going to be living in a crowded tenement flat. What this law does, by mandating that certain areas only for one-family houses, is it excludes everything else. It excludes two-family homes, it excludes apartment buildings, which we'll call parasites, if you will. In any event, the district court said, I love this quote, this case is obviously destined to go higher. Okay, he knew that this was going to the Supreme Court. And the nationwide movement in favor of property zoning laws knew this case would go to the Supreme Court also. They recognized that if the Supreme Court ruled in this case in favor of the property owners, nationwide zoning laws would fall. And this would radically change the way that progressives sought to restructure our society. So this case was appealed to the Supreme Court. And the book is a little bit of the inside baseball, which is always fun. But the case was argued once. And then it was scheduled for re-argument. Okay, this is rare. And often, this doesn't happen very much anymore. But this is usually when a case is so significant, they want to be argued one more time. And there was a brief note afterwards that apparently one of the lawyers involved in this case was from Ohio, and he knew Chief Justice Taft, who was a former president, also from Ohio. And he wrote a letter saying, "Oh, Mr. Chief Justice, would you please consider our brief? I know it's late, but can you please consider it?" And the chief said, "Okay, sure, we'll vote on it." And he voted yes. The reason why this brief was important was because of the facts of this case. Now, Cameron, did Mr. Euclid actually challenge the zoning ordinance as applied to him?
No, I think he challenged it based on how it would affect the whole.
Good. So do you guys know the difference between a facial and as-applied challenge? Okay. I love teaching today. So there are two types of constitutional challenges. A facial challenge and an as-applied challenge. Here, let me put this out for you. You have facial and as-applied. A facial challenge means that the statute on its face, that the law on its face is unconstitutional in every single circumstance. Let's just say, for example, that Texas passes a law saying the official religion of Texas is Presbyterianism. Make it easy, right? That statute immediately on its face would be a violation of the Establishment Clause. No question, easy. right? In every single circumstance, that statute's unconstitutional, right? Okay. What happens if, say, Texas passes a law saying that the governor will decide, you know, which religious institution will get tax credits, making an easier one, right? Well, on its face, that statute very well may be constitutional, right? It could apply equally. The governor can give money to every religion equally, and there's no problem. But as applied, in reality, the statute falls. What if the governor only gives money to one faith? So a facial challenge means the statute as a whole, on its face, is unconstitutional under every circumstance. As applied means in specific circumstances, when the law is being enforced against me, it's void. Right? Facial means it's always unconstitutional. As applied means when it's enforced against me in a specific injury, that renders it void. So Cameron, I think you said already, but was this case a facial challenge? Or was this case an as-applied challenge?
It was an as-applied challenge.
No. Had he even built anything on the land?
No, they hadn't done anything.
Exactly. This is what you call a pre-enforcement facial challenge. Everyone see that? He hadn't even built anything. He could not have even been in violation of the zoning law because he hasn't built anything. It was an empty lot. This is what we call a pre-enforcement facial challenge. The city had not enforced a law against him, therefore was not as applied. Everyone get that? So suing under an as-applied challenge is a lot more difficult because you have to effectively show that in every circumstance, the law is unconstitutional. As applied to every single piece of property in Euclid, Ohio. I'm sorry, in Euclid, Ohio, the statute is unconstitutional. Whereas, say you tried to build a house in an area zoned for say you tried to build a factory, right, in an area zoned for residential, and they sent him an enforcement saying you have to demolish this building. All you would have to show is that as applied to him, that the enforcement's unlawful. But because he sued as a facial challenge, he was trying to take down the entire system. You had him?
Yeah.
It's okay, he was scratching.
Yeah.
Close to it. Okay? So the brief that was referenced, right, the brief sent to Chief Justice Taft made this point. They said, listen, don't rule that all this stuff is unconstitutional. All you need to do is say, as applied, this may or may not be constitutional. Okay? Kaler, could Ambler, the plaintiff in this case, have even alleged that he was injured by this law at this point?
No.
Exactly. There was no injury. He hadn't built anything there yet. And because he hadn't built anything there yet, there was nothing to sue over. That's why this case was dumped. Right? So this is a litigation strategy that you will likely face at some point in your life. Suing a facial pre-enforcement challenge is very difficult because there's been no injury yet. The court will say, I'll tell you what, go build your thing, let them send you an enforcement action, and come back later to court after you've actually been enforced. You can't do it yet. Yeah, 1, 2. I'm gonna.
But I remember when the property value went down to 2,000.
Those were estimates, right?
But
At what-
injury?
At what point we actually did this? Remember we discussed the case of how do you price houses during a foreclosure mess?
Might do the sale.
Yeah. But the point is, until the land's actually sold, have you lost any value at it? Until you actually sell the land, you suffered no injury. It's enough to say, yeah, my property value, the estimate's gone down, but until you actually sell it, you suffer no injury. In other words, generally speaking, you can't sue based on anticipated loss of value.
Why in covenant, when a value of property goes down by a substantial, say it has harming somebody else, the property value, is that not? Did I just make that up?
You talking about changed circumstances? I
I
think you
just
may be.
remember hearing when property value goes down.
So there's some situations, right, where a government regulation has the effect of taking away all value of your property. In very rare situations, the government may have to actually pay for that, but that's a rare situation. Here, there's no allegation that it takes away all of your property value, right? This way some, but you're on the right track. Represent your same point? Yes. Okay, good. I love when students are on the same page. Because like, again, you guys are a cognitive web. It's great. So we have the situation, right? In this case, Ambler hadn't built anything yet, so he brought a pre-enforcement facial challenge. Now, I'm not trying to beat up Mr. Ambler here, right? I'm not trying to be mean to him. Because what was the alternative? Okay, wait. Paul, let's say he needed a mortgage to build a factory on land that was zoned for residential. Do you think any bank would have given him that mortgage to build a factory with the zoning law hovering over his head?
No.
Why not?
Just it's too risky.
It's too risky, right? So there's something of a catch-22. There's no way he can build a factory on that land because no one will give him the money to do it, and he'd be an idiot to even try. But until he builds it and they tell him no, he doesn't have an injury, right? So in this sense, probably the only meaningful lawsuit he could have brought was a pre-enforcement facial challenge. So he basically had to hang his entire hat on a hope that the Supreme Court would find that zoning laws in their entirety, in every instance, in every application, would be unlawful. Okay, everyone get the gist of the background, how that works. It's a very interesting case from a litigation perspective because there's a lot of very sharp lawyering going on. All right, any questions before you get started with facts? All right, so let's talk about the actual zoning law. We have here, I have a picture of the actual property. So the way to think about zoning laws is like a pyramid, okay? And you have these numbered usage. You have, at the top, you have U1, then you have U2, then you have U3, and you have U4. So at the very top, just make it easier, you have U1, use 1. That is for usually one family residential. That's like the pinnacle of the pyramid, the very tippy top. Okay? Marcella, when you have land that's zoned as U1, can you build a factory there? Can you build an apartment building there? What can you build there? That's it, okay? But let's say you have a land that's zoned U6, like the one up there, right? U6 is zoned for commercial or industrial, right? Marcella, can you build a factory on U6? Yes. Can you build a one-family house on U6? Yes, that's the key point. You can always build up. If something is zoned U6, you can build anything there. You can build a factory, you can build housing, you can build an apartment, whatever you want. But if something's zoned U1, you can't go down. You can only build a one-family house. Right now, who would want to build a one-family house in an industrial zone? Probably no one. So the effect of it is to limit it to whatever is the lowest common denominator. So in U6, people are only going to build industrial, right? In U1, people are only going to be allowed to build one-family houses. If apartments are allowed in U3, they're all being built in U3. Okay, everyone thinks so far. Now, Jessica, how does the city decide what areas to make U1, what areas make U2, what areas make U4, etc.? How does the city decide that? I'm sorry? Yeah, what do the inspectors do? Go for it.
They enforce the ordinance through the rules and regulations of the board of zoning.
And how does that board decide which areas make U1, which areas make U3, etc.? It's not, I don't think it's in your book, but how do you think they decide? Take a guess right here, on your book. How do you think the city agencies decide what to zone as U1, U2, U3, etc.? I'm sorry? Oh, it's not in the Constitution, unfortunately. Okay, one way or the other. Haley, what do you think? How do you think that they go about deciding what should be 1, 2, 3, 4, 5, 6?
They like to look at economic considerations and like the future, what they think cities going to develop into.
Yeah, okay, good. They're trying to follow what's called a comprehensive. The key phrase is comprehensive plan. And someone in city government somewhere writes a plan. That might be a paragraph, it's not have to be very long, that says, we want to design the city to look a certain way. We want the city to feel a certain way. And in the case of Euclid, Ohio, which, as we said a moment ago, is a suburb of Cleveland, you had a very busy, expanding, industrial city. At the time, Cleveland was booming. And you have this little suburb called Euclid saying, wait a minute, we don't want all this industry to come here and ruin our, our pastoral little town. So what are we going to do? We're going to limit the areas where you can build industrial stuff. We're going to preserve the areas where we can build family housing to make sure that our families have a nice, safe, clean, quiet place to live and grow. Through the use of zoning and having different sections here or there, they can actually exclude undesirable uses. They can exclude undesirable uses. So let's take a look right here at this map we have here. Okay. So we have the main street, Euclid Avenue. Behind it is the railroad tracks. And we have here a roughly 18-block stretch. And I found it on Google Maps. You can see it here. What it looks like. You have the railroads back there. You have Euclid Avenue here. You have 204th Street. You have 196th Street. And you have this massive now industrial park. Okay, that's just to get a sense of what it looks like. There's actually a it's actually called the Euclid Business Park. I have some pictures of what it looks like today. It's all industrial stuff. So, Urvashi, let me ask you this question. How do you think the city decided to chop up this single lot into 3 pieces?
I guess they looked at whether or not it would be difficult to build anything else on it and what was already on the lot.
So the lot was empty, right? It was an empty lot to start. Why do you think they chopped it up the way they did? Well, think about it. So, Urvashi, what's U2? What can be built on U2?
That is 2-family dwelling.
Exactly. Okay, U2 is U2 family dwellings. What about over here, U3?
Apartment houses.
Okay, so we have here 2 family dwellings in this little piece. On this tiny little piece, we have apartment buildings, and then what's U6? Okay, Jeffrey, you're laughing. Why are you laughing?
Well, I mean, the owner, he was sort of upset because he felt that it would be valuing the land by zoning it the way they zoned it.
Okay, does everyone see this is ridiculous? Does everyone agree? Now, I'll be charitable, right? We'll defend it. So probably this is thinking, okay, you know what? This is near the train tracks, right? So let's put some industrial stuff to buffer for the train tracks. And this is near the main street. So we'll put a 2-family house here. Let's make this little insignificant slot U3 so they can't build anything there. So you can't have an apartment building this big, right? Right. The apartment buildings are usually bigger than the 2-family houses, generally speaking, right? So let's make it basically impossible to render this strip of land absolutely worthless. And okay, let's see who's going to build a 2-family house right next to an industrial yard behind the train tracks. Okay. Even though they went ahead and made this 2, 3, 6, for all intents and purposes, this entire thing is 6. Everyone get that? Because you have so little space for U3 to build an apartment, you're not going to be able to. And because you have this U2, a 2-family house, it's not going to sit behind a factory. So basically, the entire land is basically only usable under the zoning regime as factory. And indeed, if you look at it today, the entire thing is an industrial park, even though it was originally zoned to have possibility of family housing. Okay. Now, why did the city even bother putting this worthless 2 and 3 slot right there? Okay, so little inside baseball here, but cities try to make it seem like they have a land available for low-income housing. Actually, I emailed Dominique about this, but the Mount Laurel case we'll do in a few weeks. Cities say, look, we zone all these acres for affordable housing and apartments, right? We have a little bit over there, a little bit over there, a little bit over there, a little bit over there. And if you add all those acres together, you have all these acres for affordable low-income housing. But, okay, this is stupid because you can't build an apartment building on a 5-feet slot, right? So this was probably some sort of effort to, if you add up in the aggregate, the total amount of 2 and 3, U2 and U3, it seems like a big number. But in reality, this entire lot was reduced to U6 in practicality, right? Everyone see that? Right, so Rachel, what did this actually do then to the value of the land for the Ambler company? Yeah, but how much? Yeah. So effectively, this reduced the value of the price of the land significantly. So it says here in the book, without the ordinance, the land's worth about $10,000 an acre. Okay. With the ordinance, it's worth $2,500 an acre. Okay. It basically takes land that if you could build whatever you want in the entire thing, it would be very valuable. Now, it's somewhat perverse, but generally the most expensive land is used for one-family housing because it's the rarest. In any given city where there's actually zoning, what's called actually Euclidean zoning after this case. Euclid was a father of geometry, so it's a fitting name. So in any city that uses Euclidean zoning, U1 is the rarest, that's the most expensive. There's always been a bunch of U6 there, right? But who wants to build a house in an industrial area? So Ambler comes and says, wait a minute, you guys, you deprive the value of our land significantly. You cut down the worth of it. You basically made it so I can't build anything here but industrial. I'm going to sue you. And again, this was a pre-enforcement facial challenge. They challenge the law in its entirety. Okay. So, Aaron, how did the Supreme Court, the Supreme Court of, was it 1928 or so, under the stewardship of Chief Justice Taft. I don't know if I mentioned this, but Chief Justice Taft was also the president. He was huge. He weighed almost 400 pounds. He would often get stuck in his bathtub. He was so big. He actually once broke a horse's ankles. And then someone gave him a gag gift of an elephant, so we should ride that instead. Yeah, dude was huge. It's actually a deceivingly small picture. I mean, I actually clerked in the 6th Circuit in Ohio where he was a circuit judge, and the actual chair he sat in was still there. And like it was like this big. It was this humongous chair. It was like something like an elephant would perch on. All right, Aaron. So how did the court go about understanding this issue?
They decided that the ordinance was constitutional.
Okay. How did this law, Aaron, comply with the Due Process Clause of the 14th Amendment? Okay. So this health, safety, moral welfare, what do we call that? You just said it. No. What's that power called? You said it a few minutes ago. But we said it maybe 20 minutes ago. What do we call the state's power over health, safety, welfare, moral? Police power, bingo. The court basically said this is not a taking of property without compensation. This is not a deprivation of property without due process of law. This is an aspect of the police power. That this regulation is permissible under the police power. And the court says, look, the line between legitimate and the illegitimate assumption of power, it's not capable of precise delineation, right? You can't narrowly define it. Okay.
You just said it was unreasonable, or if it was unreasonable, they could overturn zoning. But when we were just looking at it, we basically said that part where it's U3 basically rendered it unusable. Would that not be unreasonable that they rendered it entirely?
So what does the court say here, right? Ryan, has this law actually been enforced against Mr. Ambler? Has it been enforced yet? So what they effectively say in the last paragraph, which we'll get to later, is come back another time, bring in an actual challenge.
How do you bring a challenge that piece of your land has been considered unusable?
So this is the rub of Euclid, right? This is why this case was so significant. The Supreme Court basically washed its hands of zoning law. They basically structured it that it would be impossible to challenge these laws before they're enforced. And even after they're enforced, they're extremely deferential to the state. So this is mentioned in a note after the case, but there was one zoning case about a year or two later, 1928 or 29, whatever it is, Necktown, Cambridge. After that, the Supreme Court didn't touch zoning for 60 years, or 50-something years. After this case, with one small one that came afterwards, the Supreme Court did not touch zoning for nearly 60 years. And the lower courts took the signal, which means green light. Any zoning law goes. And we'll study a number of cases where, in rare instances, courts found the application of zoning laws been reasonable. We'll do one next week and maybe one the week after. But those are the outliers. After the court's decision in Euclid, virtually every single zoning ordinance was upheld without fail. The court said, we're not getting involved here, right? Jeffrey, why was a court so hesitant to get involved with these sorts of zoning decisions? Why did the federal Supreme Court not want to nitpick about this zone U3 is too big and that U2 is too small? Why do they want to stay out of this?
You're sort of forcing the federal government to sort of meddle in the business of local
Federal courts, not the government.
Well, federal courts getting in the business of now state decisions or local decisions.
Yeah. So I think you can sense in the court's decision, again, this is by Justice Sutherland, who was a fairly conservative judge, one of the so-called four horsemen of the apocalypse. He did not want to be in the business of having the federal courts micromanage local zoning decisions. Okay? He started from the presumption that states have this police power, and courts are not equipped with the expertise to second guess this sort of decision. Okay? Now, Dagny, the court's decision, though, also seemed to see a very strong value in zoning. What value did the court see in having these sorts of zoning laws? Why did this hit so close to home for the justices? Yeah, what are the economic benefits of zoning? Well, is zoning bringing business in? What's the zoning the effect of doing usually? Yes, zoning is about restricting business and promoting. What's the pyramid promote? Residential. Zoning is about promoting residential housing, right? So effectively, the justices, and they liked having the idea of keeping out poor people. I don't have to say that too lightly, right? The entire idea of having a one-family house is about promoting big, spacious areas with backyards that the kids can run around. Poor people can't afford houses with backyards. They want to live in apartment buildings. When you have a little zone 3 this big, you're not going to have space for housing. So as much as zoning is about making things aesthetically pleasing, and beautiful and nice, it was about spacing things out and keeping away things that the city planners, the elites, did not want. Okay. Yolanda, how did the court refer to apartment buildings? What do they see apartment buildings as? How do they describe it in a very, very vivid language? Yeah. Yeah. The court called apartment buildings like a parasite. They take advantage of open spaces and attractive surroundings. Okay? What you have to remember about this is that in 1928, cars were fairly new. Before the 1920s, the idea of a commute didn't exist. Unless you can get somewhere by train or by some sort of a horse and carriage, you couldn't travel long distances. But once you had the car, people can move out to a suburb, right? You can move to Sugar Land or wherever around here and have a commute because you can drive in town. But once you have this commute, people from the city are like, wait a minute, I don't want to live in the crowded city anymore. Let me go build a tenement flat, in Sugar Land or wherever. Zoning law prevents that. Zoning law says, oh, no, Cleveland, you stay where you are. You're not coming to Euclid. Right? And the court parrots that parasitic language. They call apartments parasites. They call them even nuisances, right? And they say we need to keep out these cramped housing to go away. to keep away these bad things. So it's one thing to say we don't want industrial, right? Going back to our map up here. It's one thing to say, you know what? We want to keep industrial out. We're going to keep industrial away from the main street. Okay, fine. But then how do you justify keeping out apartments? Because people are not industry. People are not commercial. Well, the reason they want to keep the apartments out is they don't like poor people. And I say this as a red-blooded libertarian. But zoning laws are aimed at exclusion. And there's really no way around it. And if you live in areas that are zoned, one of the key factors of zoning is to maintain property prices. You'll study this next week and the week after. One of the key reasons why zoning laws exist is to maintain property prices. Anything that can make property prices decrease, zoning boards can stop. So it effectively tries to keep economic levels the same. It makes it impossible for other people to build housing in that area. You'll see this in the Mount Laurel case, which I keep coming back to, but it builds to a crescendo in that case because effectively the city made it impossible to actually have any sort of low-income housing because you have these little dots here and there, but you can't actually build enough to have a little have a house. Okay. Yes, sir.
So in our case, by dividing up this parcel like this, what is the purpose? I don't really understand.
So again, I'm speculating a little bit here, right? But the purpose is to render the entire thing U6 while pretending to have at least some room for apartment buildings, right? Because if you look at it, it's like, look, there's, you know, an entire area there, X number of acres, which can be used for apartment buildings, but in reality, you can't build anything in a lot that small. So they're trying to total in the city the total number of acres for small, you know, 2-family apartment housing, but in reality, they can't. So this entire area by the railroad tracks is only going to be industrial. In other words, they don't want 1-family houses next to the industrial. So this creates a little bit of a buffer zone.
Would it be all industrial? Would it be good for property?
Which land has the highest value, industrial or 1-family housing? Exactly. So the value of the land is highest for 1-family housing because it's the most rare. So by making it industrial only, they've reduced the value of the land.
But it hasn't rolled down. It really effectively use it because U2 is, I mean, you can't make industrial on U2.
Yeah, I agree. I mean, if you can't build industrial on U2, but people don't want to build on U2 because there's industrial right there, then you've only given them half this property that you can sell as U6, and the other is crap single family house.
Well, okay, so what happens where this is U2, right? You can't build industrial there.
Yeah.
You can only build industrial in the back half, okay? But people are not going to be building 2-family houses across the road from a factory. So in reality, of course, it's possible to build a 2-family house here and an itty-bitty apartment building on U3. Realistically, you're not going to be able to. And the only thing you'll build is a big industrial in the back, and the front half is worth crap, to use your words. It's basically worthless. Okay? There's not even a street intersecting it. It's the actual same lot. And you render roughly half the land unbuildable. So you can only build a U6 factory in the back. Okay. One point the court stresses, though, is at the end, when they say many applications, as applied, may be, quote, arbitrary and unreasonable. Right? In other words, come back later after you're actually challenging a specific enforcement. Don't bring us these pre-enforcement challenges. But as we discussed, it's not very helpful to someone whose land has just been diminished in value, and they won't be able to build anything because it's going to be demolished once they actually have it over the line. Okay. Okay. Any questions on on Euclid? Any questions on Euclid? All right. Any questions? Okay. Other Ryan?
I don't understand why I mean, could you have basically made a sham building that was over a certain amount of feet tall and then just brought it as an as-applied point, like just to do? Because I mean, I feel like it was fairly obvious.
So here's the deal, right? And this is something which people don't realize when they read Supreme Court cases. These cases began 5 or 6 years earlier, and they probably had small county lawyers who didn't really know what they were doing. Right? I'm not saying this is a pejorative, But when this case began, you probably had a guy saying, listen, this diminishes my property value, let me go sue, right? He didn't anticipate that his case would be the Supreme Court's decision. And it's very difficult to know in advance. That's why if you ever do any cases where you want this to go to the Supreme Court, you make your facts perfect. The hardest part of beginning a Supreme Court case at the outset is make sure you don't have what are called vehicle problems, right? That there are facts here that aren't good or they're bad. Just make sure that your vehicle, your facts are perfect, and the Supreme Court won't ding you on the details. But I doubt when this case began, it had any idea where it was going. Any other questions on Euclid? Okay. So this is the introduction to zoning. The rest of our topic on zoning presumes that in the abstract, zoning laws are constitutional. In the abstract, zoning laws are constitutional. But in very specific cases, in very specific instances where a city acts unreasonably, courts do step in and find that they're unlawful. These are rare cases. In very rare cases, a court will find that a zoning ordinance is beyond the police power of the government. But these cases are the outliers. All right? And I want you to remember this very clearly, because almost 99% of the time, if you ever deal with a case, the zoning ordinance is constitutional. Very rarely do federal courts get involved. Almost never the federal courts get involved, usually state courts, very rarely. Careful. Okay, so any questions with that? I want to briefly talk about your fine city, Houston, which is given a very nice shout out in the reading. So Houston, as a city, stands alone in America as the only major city without a zoning code. Okay, in Houston, we do not have use-based zonings where this area is for residential, one family, this area is commercial, this area is for apartment. We don't have that. Okay, and one of the most vivid examples of this is the Ashby high-rise, where maybe you'd ever go near Rice Village, I'm sure you've seen these signs planted along the sidewalk. So there was a proposal a number of years ago, and this keeps going on, to build a high-rise on Ashby and Bissonnette, which is right near where the museum district is, near Rice Village. And the neighbors mounted a very concerted effort to stop this. Now, if this were any other city, an area that was only residential would not allow the construction of a high-rise condominium. But because Houston doesn't, the neighbors have to turn to alternate means of protesting, of complaining at every juncture, of complaining about the noise, complaining about the traffic, complaining about everything imaginable. Finally, about 2 years ago, all the courts said, you know what? There's nothing you can do to stop it. And at the last minute, the neighbors sued for a nuisance. I think I mentioned this, but they actually claimed that the Ashby high-rise is a nuisance. Why is it a nuisance? Because it's out of place. They define a nuisance to be something that's out of place, a non-conforming use. This is an absolutely wrong definition of a nuisance, but it's on appeal as we speak. Ultimately, the court held that, well, they can build it, but they have to pay damages, like Boomer. So we have a situation where the jury held that this building was a nuisance, but damages are awarded. But I want to actually push back and question whether there's actually no zoning in Houston. And the short answer is there is, but it's not using the Z word. So if you ever have Professor Matt Festa, he's written on this extensively, but I'm going to summarize it briefly. So your fair city has what I actually started calling backdoor zoning, right? Different ways of accomplishing the same sort of zoning. So one way is called minimum lot sizes. Minimum lot sizes. Until 1998, if you were inside the loop, inside the 610 loop, all lots had to be at least 5,000 square feet. Okay, at least 5,000 square feet. What's the significance of this? You couldn't really build a lot of house on 5,000 square feet. This stretches things out. Because if you're building a one-family house, you still need a 5,000-foot lot. And there's a lot of space on all sides of you. And this is the effect of stretching things out. This also makes land a lot more expensive. Every square foot of land you buy is money. So if you're making someone spend $5,000 on a square foot of land, it becomes very difficult to afford a two-family house or a three-family house because it's expensive. So this is why, generally speaking, within the loop, most houses are one-family house. After 1998, they actually changed it. So within the loop, you saw the 5,000 requirement, but outside the loop, it does not apply. Another quasi-zoning tool, so with parking spaces, we realize here in Houston, virtually everyone drives everywhere. It doesn't bother me much. But you may not know this, is that the city actually imposes requirements. So for every one-bedroom apartment, okay, development, you're required to have 1.25 parking spots. For every one-bedroom apartment, you need to have 1 1/4 parking spots, assuming that people have basically 1 1/4 cars. So for more or less every bedroom in a development must have at least 1 parking spot. Parking takes up space, and that again stretches things out. And because there's so many parking spaces, people tend to drive more. Even in a place like a bar, every 1,000 square foot in a bar, you need 10 parking spaces. Why are people driving to bars? I will let you discuss that, okay? But you need to have even lots of parking for things like bars. A consequence of having so many cars in Houston is that they're mandated very wide streets. And I always think of Westheimer by the Galleria. Once years ago, my parents visited me for the first time, and they stayed to Sheridan, no, on West Loop right by the Galleria, and they wanted to walk to the mall. I told them, what are you doing? Are you insane? They're trying to cross over Westheimer. I've never even tried this, but I'm assuming it can be done. In Texas, major thoroughfares are 100 feet wide. Okay, they're meant to fit usually 4 and 4 lanes. But a consequence of very wide streets are small sidewalks. In fact, most places in Houston have no sidewalks, or if they do, they're about 4 feet long. So as a result, the streets are very wide, the lights are short, the hard to cross, and there's not many sidewalks. As a consequence, there's not much walking in Houston. We have some stuff in the Heights and in the Montrose area, but generally speaking, Houston does not allow for walking. Another requirement is that there are very long blocks. If you notice, streets are long. And in, for example, the Galleria, usually streets are about 600 feet apart. So there's not many places to cross over. It makes also walking very difficult. Okay. Another element, and this one's very unique to Houston, is that we have no zoning, but we have lots of covenants. And you see this everywhere. Signs say deed restricted community. You seen these signs? They're everywhere. Deed restricted communities. What happens? All the people in a given area agree to restrict each other's property. So even though there are no formal use districts, as a matter of course, if an area is deed restricted to residential one family, that's what it is. But what's unique about Houston, and this is very unique, is that the city attorney can defend covenants. If the private parties, in other words, those who benefit from the covenant, the dominant estate, they do not sue on the covenant, the city attorney can step into their shoes and sue on the covenant. As a result, the city can effectively enforce, assure that covenants are complied with. Not many cities actually allow this. This is very, very, very unique. Okay. So as a consequence, Houston, which looks very distinct, and I like this picture because it shows basically residential stuff across the street. If you ever drive down Dallas Street going towards downtown area, you have residential, boom, high rise, right? And it's a very sharp dichotomy. And I love this picture because it shows how clearly you have a city concentrated, spread out. You have the medical center over there, you have the gallery over there, and different neighborhoods. And you have Sugarland and all these other suburbs as well. In many respects, this sort of design allows for sprawl because you have to spread things out so much. But one of the attributes of Houston is that it's cheap, which I'm sure all of you appreciate one way or another. When you decrease the cost of building, land and living becomes a lot cheaper. And in fact, it's extremely easier to build in Houston than even in other cities within Texas. And as a result, the cost of living tends to be much less. Also, people find it ugly. So I don't care about aesthetics. This has never actually bothered me. If things look ugly, I really don't care. It never matters to me. But to a lot of people, Houston's very ghastly looking. It doesn't look pretty. It's not nice. It's not structured. It's spontaneous. You have, you know, La Zona Erotic across the street from Bloomingdale's, right? I mean, this is the city we live in. You can't really stop it. There have been several initiatives to actually impose zoning on Houston, and due to our city charter, it must be passed by ballot initiative. The city council can't. The city council can't enact it, and each time it's come for a vote, it has failed. One interesting aspect, and this is something I've been doing some writing on, is who were among the greatest people, the largest people who oppose the zoning ordinance was mostly minorities from the African American communities. Why would they oppose zoning? Well, increase the cost of housing, and it makes it easier to exclude, you know, low-income housing and apartments from areas. So in many respects, zoning actually makes it worse off for poor people because you can zone people out of existence. The flip side to that, as we've seen with Ashby, is that when you don't have a zoning process, only the people with means are able to stop a construction, right? They hold up these signs, no Tower of Terror. People with money can stop things, other people cannot. So there's really several sides to this debate. But Houston's a good example of how even in the absence of zoning, things somewhat develop along the same lines through private enforcements of covenants and other indirect means. All right, any questions on Houston? I sometimes do a full class on Houston zoning. I didn't do it this year because I'm doing the midterm instead. And unfortunately, I usually do a full class, but you guys lost it because the midterm, I had to use that day for that. But it's a really interesting element and fun to study where you live. All right, any questions on zoning, on Euclid, on Houston? You raising your hand?
No, just recommend it.
Okay. All right, have a wonderful day. I will see you on Wednesday.